Everyone, welcome to part 3 tutorial on general defences, and the defence we're going to look at in this session is intoxication. So intoxication is classed as a general defence because in theory it can be raised for any crime. And what we're going to look at today is how we would apply this and evaluate this defence in any scenario or essay. So we will look at the different types of intoxication once we've established what intoxication actually is, and the outcomes depending on the crime that has been committed by the defendant whilst under the influence of intoxication. Now, it's no secret that over the last 40 or 50 years, the use of alcohol has become more of an increasing problem in our society. And of course, the government has had to respond to that. There has to be an agenda on how we tackle the effects on what we call as binge drinking, but also the effects of alcohol or drug use when it becomes a dependency, so a condition, if you like. And of course, with that being an agenda of the government, the courts also have to be mindful of how they deal with defendants who raise this as a defence to a crime, and particularly those more serious crimes with high-level mens rea. So we're going to look at the rules first of all, and then we will discuss that in more detail. What is intoxication? Essentially, as you can probably gather, it covers both excessive drink and drug taking. As a general rule, although this is a defence, the courts have limited the availability of this defence to a defendant where they have voluntarily placed themselves in a state of intoxication. So they choose to drink alcohol or they choose to take drugs, particularly prohibited drugs, those unlawful drugs. If they choose to do so and commit an offence, the general rule is that they most likely won't be able to rely on the defence, but we will look at that in relation to specific crimes. If a defendant has become involuntarily intoxicated, the defence will more likely be available to them. And have a think why. I mean, essentially, what a defendant would be if they become involuntarily intoxicated. So if they're spiked, or they take a drug that has, or drink that has the opposite effect to which they could ever realise or understand, then essentially they are blameless. They become intoxicated through no fault of their own. So you can see from a policy point of view, this would be an instance where the courts and, of course, the government would see that more leniency should be available. So first of all, we would need to identify how the defendant has come to be intoxicated. Is this through voluntary circumstances or involuntary circumstances? So what the defence is, in essence, is that if you raise intoxication, you are saying that you were so intoxicated, so of course we have to look at the level of intoxication, that you are incapable of forming the required mens rea of the offence. And of course that may extend even further. If you are so intoxicated through drink or drugs, maybe that renders you being unable to commit voluntary acts as well. Maybe you end up with no control over your physical actions, which of course extends to automatism as a defence as well. Automatism is about no voluntary control over your actions. But primarily this is about the mens rea. This is about your state of mind. And of course, as I said, we have to take heed of the level of intoxication as well. And practically, evidentially in courts, there are experts who give evidence on the effect of intoxication on a defendant. And of course, we have levels of acceptable intoxication in our legal system. If you are given a breath test, there are certain levels, millilitres of alcohol in your breath that the police would be looking for to determine whether you are over the legal limit for driving, for example. In some countries, there is a zero tolerance policy on that. Any slight detection or trace would mean that you would be criminally liable. But here we do have the levels, and the dangerousness of having levels, acceptable levels, is any expert will tell you that it depends on the defendant themselves. A whole number of factors taken into account: height, weight, age, the amount that you've eaten that day, the level of physical activity that day, and generally, there's a load of things that are taken into account, the amount of sleep. So what could be acceptable as a level for one person wouldn't be for another, and could actually render you being over the limit. So, of course, this is a defence that a defendant may want to raise, but what they're saying is the level of intoxication was so great that they were incapable of forming the crime. And as we've looked at with previous defences, the general principle still applies. If you raise a defence, there is a burden on you to bring evidence to show that you were acting in that particular way. So for a defendant here, the burden would be on them to prove that they were so intoxicated that they were incapable of forming the required elements of the crime, the required ingredients needed, the actus reus and the mens rea elements. And what happens is, even if the defendant can prove that they lacked the required mens rea, for some crimes they might still be liable, and this depends on the type of crime that they've committed. Now, the courts categorise all crimes into two. They lump them into two categories, and this is a basic intent category and a specific intent category. Now, we have looked at these rules in relation to automatism. When we come to the third test of automatism, is the defendant blameless, or have they induced themselves into a state of automatism? The same rules apply here for intoxication, in terms of we have to look at what crime the defendant has committed to establish whether they would have a defence or not. So let's have a look at those categories. We have two. We have specific intent crime categories and basic intent crime categories. Now, I haven't put them up here because I'm hoping that you can remember, for the purposes of OCR law, what those different crimes are. So specific intent crimes are those with the intention to do something specific. So it's not a basic intention or any recklessness. This is intention to do something specific. With basic intent crimes, on the other hand, these crimes include the mens rea of recklessness. So you could form the basic intention, so intention to cause some harm, for example, or the realising of a risk that a crime would be committed. This is a lot lower level mens rea. Recklessness, of course, is the lowest level that you could be culpable of. So just pause this and see if you can please write down the crimes that would come under specific and the crimes that would come under basic. So hopefully you've identified for specific intent crimes, these would be murder, Section 18, grievous bodily harm or wounding. So on the basis that for both of these, you need to have intention to either kill or cause serious harm. Property offences, which have specific mens rea of both dishonesty and, of course, the intention to permanently deprive the other of the property. And then you have attempts, which require specific intention to commit those crimes. So for attempted murder, it would be intention to kill, if you remember through the case of Wybrow. For the basic intent crimes, you've got crimes of manslaughter. So remember, unlawful act or reckless manslaughter cover recklessness in particular. You've got Section 20, grievous bodily harm or wounding on the basis of intention to cause some harm or recklessness as the mens rea. And then, of course, you've got the assault, battery, and if the injury is greater, the assault and or battery occasioning actual bodily harm. All of those require basic intention or recklessness there. So just note that for property offences and attempts, there are no kind of corresponding basic intent crimes. So if you wanted to drop somebody down from a specific intent crime of murder, you could charge them with manslaughter instead, if it's corresponding alternative basic crime. And the same for Section 18, grievous bodily harm or wounding. The alternative crime that the prosecution could charge would be Section 20. But there are no reckless property offences and there are no reckless attempt crimes. So there are a couple of gaps here, which is a bit of an issue, as we'll see later on. But what we're going to do now is go into the rules of voluntary and involuntary intoxication. So the rule for voluntary intoxication is if you become voluntarily intoxicated and you are evidentially incapable of forming the mens rea, then you may have a defence to specific intent crimes, but not to basic intent crimes. So this rule comes from the case of Beard, Director of Public Prosecutions, running the case, the appeal against Beard. So Beard was a defendant who, whilst intoxicated voluntarily, raped a 13-year-old girl. Whilst doing that, he put his hand over her mouth to stop her from screaming. She ended up dying of suffocation. He raised intoxication here and claimed that he didn't intend to kill her on the basis of that. He was charged with murder as the primary offence. This case went all the way up to the House of Lords, as it was then, and famous judge, Lord Birkenhead, his name is, said, essentially, if I summarise kind of what he said, until the 19th century, voluntary drunkenness has never been an excuse for criminal misconduct and was actually considered an aggravating feature. You see, we've talked about this before, the fact that intoxication could be an aggravating feature when sentencing and could, in fact, increase the sentence. So it's really bizarre to think that it could also be a defence. It could be something that lessens your culpability. So Lord Birkenhead is recognising that this is really serious. Intoxication usually aggravates the seriousness of a crime. But what he then went on to say was that where a specific intent is an essential element of an offence, and the state of drunkenness renders the defendant incapable of forming that intent, then he cannot be convicted of that crime. So where Beard here was so drunk, through his own volition, of course, but was so drunk he couldn't form the intention to kill or cause serious harm to this poor victim, legally he just simply cannot be convicted of murder. And what Birkenhead went on to say was that therefore he must instead be guilty of homicide unlawfully without the malice aforethought, and that is manslaughter. So the rule is if you cannot form the mens rea for a specific intent crime, then you should be charged with the basic intent crime instead, the corresponding basic intent crime. Okay, and that's the rule. But as I pointed out to you in the previous slide, not all specific intent crimes have alternative crimes to charge. So if Beard had committed theft, burglary or robbery, or an attempted murder, he would not have had an alternative crime to be charged with. And if you cannot form the mens rea for that specific crime, then what happens here is that the defendant has a complete defence. So the outcome essentially is, if there is an alternative basic intent crime, the defence acts partially. It lowers your liability to the next crime available. But if there isn't an alternative basic crime, you have a full, complete defence. So this acts partially or fully, depending on the crime you commit. Is this fair? Potentially not, because it's almost luck, really, depending on the crime you commit, as to whether you have a partial or full defence, even though you are voluntarily putting yourself in that state of intoxication. It is an issue that is recognised by our reform bodies. But you might ask, well, why, if you're voluntarily intoxicated and incapable of forming mens rea, are you guilty of a basic intent crime instead anyway? Why would you be guilty of manslaughter if you can't form the mens rea? And this is what the next slide is about. The reasoning behind this comes from the case of Majewski, 1977. So the defendant, Majewski, had been taking drugs and alcohol and was involved in a fight with 3 people. He also attacked officers who tried to arrest him. So he was convicted of a number of offences, mainly ABH, actual bodily harm, under Section 47, and also assaulting police officers. He raised intoxication. What type of crimes are these? If you go back to your table, hopefully you can see these are basic intent crimes where only basic intention or recklessness is available. So you could be guilty of a crime if you realise the risk of committing the crime and go ahead anyway. He was unsuccessful on intoxication. What the court said was intoxication is not available for crimes of basic intent, so those involving recklessness as well. And they said this is because the act of voluntarily becoming intoxicated is seen as reckless conduct in itself. So I wonder what you think about the fact that if you decide to get drunk or decide to take drugs, therefore by law you are seen as reckless and you can be found guilty of any subsequent basic intent crime where recklessness is the ingredient. So it's a very blanket approach to finding defendants still guilty despite being intoxicated. So for specific crimes, they have more of a chance of being found not guilty, partially or fully. But if you commit a basic intent crime, you are deemed to be reckless, and therefore intoxication will just simply not be available to you as a defence. And that was the case in 1977. Although 22 years later, we had a bit of a development. Involved 2 defendants, 2 students, Richardson and Irwin, who caused serious injury to another student. Obviously, the whole instance, or on the facts, they were all drinking and they were all mucking around, what we call horseplay by law, which, as you know, could amount to consent if somebody is harmed, but of course serious injuries take you out of the realms of consent for the most part. These defendants raised intoxication. They said they couldn't form the mens rea to the causing of the serious injuries, the grievous bodily harm injuries. And this did go up to the House of Lords as a point of appeal. And in the end, they were not guilty. And that's because the House of Lords decided to expand the principle of Majewski, rather than saying you're absolutely guilty based on recklessness, through drinking. You should have foreseen that something like this may have happened or would be likely to happen. The question, in fact, was would the defendants themselves had foreseen the relevant risk of committing that crime had they have been sober? An interesting question, because you might think, well, if you lift students over a balcony, or a student over a balcony when sober, it's possibly foreseeable, isn't it, that they would have suffered serious injuries. You'd see that risk if you were sober. And of course, that's the point, really. If you can't see the risk when you're drunk, then arguably you're not reckless. So they were not guilty. And what this actually does is this makes the recklessness test a bit more subjective. This is about whether the defendant, their sober selves, would see the risk. And if they would see the risk, then of course we have to compare that. So they're being compared to their sober selves, if you like. So it does kind of widen the availability of the defence. Because, of course, if you foresee the risk yourselves when sober, you wouldn't go on to commit it. If it's the drink that impairs that foreseeability, then, of course, arguably the defence should be available. So I hope that makes sense. We'll go on to another principle now. And this is one of Dutch courage. So what happens where a defendant has formed the intention to commit a crime before they actually commit the crime, and they drink to build up the Dutch courage to commit the act? This originates from the case of Gallagher. Again, a very important case because you have an Attorney General here taking control of the prosecution. It's not Liam or Noel Gallagher, so it's simply the picture's there because of the name. So the facts are Gallagher wanted to kill his wife. He bought a knife and a bottle of whiskey, which he drank to give himself the courage to do it. Once intoxicated, so once in the state, he stabbed and killed his wife with the knife. Now, he argued, at the time of the crime, I was intoxicated, so therefore I couldn't form the mens rea. He was convicted, went up to the House of Lords, and they upheld his conviction for murder. They said he had formed the relevant mens rea at the relevant time. And the famous phrase was, a drunken intent is still an intent. Which makes sense. Why would you want a defendant to have a defence, partially or fully, when they've made a decision to commit a crime and then they drink to give them the courage to do it? But of course, if you think strictly about the legal principle, at the time of the crime, arguably, he may not have been able to form the specific mens rea. And of course, remember, if we go back to our principles of criminal liability, the actus reus and the mens rea have to coincide. They have to meet, they have to overlap for a defendant to be guilty. This arguably means that a defendant has formed the mens rea prior to the crime, but then the mens rea is absent at the time of committing the crime, and we only have the actus reus, which would mean there is no coincidence. But, of course, the House of Lords here, by saying they've formed the relevant mens rea at the relevant time, they're recognising there is a link there, forming the intention prior to the crime. The circumstances of this really, on a policy level, a public safety level, would dictate that this defendant had to be convicted. But you can see the dilemma here. Okay, so we'll move on to involuntary intoxication, which is a bit more wider, a bit easier to be successful on, because, of course, with involuntary intoxication, you are claiming that this has been against your will. There's no foreseeability here. These are situations where you didn't intend or didn't want to become intoxicated. And the potential situations where this could occur more commonly than ever, being spiked without your knowledge, and being unaware that you are consuming the drugs or alcohol. Taking prescription drugs, those that maybe have the opposite effect or have serious side effects that you wouldn't have been aware of, or having an unexpected reaction to drugs that would otherwise calm you. So remember, soporific means calming. So these potential situations give rise to involuntary intoxication. Of course, we still have to identify the level of intoxication, because you could be spiked but with a very low level and you may still know what you're doing. Side effects may be very minor, and again, you may still be able to form the mens rea. So the burden is still on the defence to bring evidence to show that not only was this a case of involuntary spiking or intoxication through the circumstances, but also the level meant that the defendant still couldn't form the mens rea. And there are two kind of key cases in this area that I want to raise your attention to. So on the basis of drugs having opposite effects, you've got the case of Hardie from 1984. So hopefully you can remember the facts of this, because we've looked at this in relation to automatism as well. This was a defendant who took soporific drugs, so Valium, which ended up having the opposite effect on him. Obviously, Valium is used usually to calm. He'd just gone through a bad breakup. These hadn't been prescribed for him, which I think people always struggle to understand the court's decision of success here. Because if you take drugs that are not prescribed for you, then surely there is a realisation of a risk in taking these drugs. These also, to add to this, these drugs were in fact out of date, so you'd think that would maybe add to the recklessness here. But nevertheless, he set fire to a wardrobe with ex-girlfriend's clothes within it, and he was charged with criminal damage caused by arson under the Criminal Damage Act. He said at trial he remembered nothing of the incident due to the intoxication. He was convicted because the judge initially directed the jury that this was voluntary intoxication on the reasons I've just said, really. This is a taking of drugs that aren't prescribed for you. So therefore, surely there's a realising of the risk here. But on appeal, the court overturned that decision. They said the Valium was taken to calm his nerves because of the breakup. There was no evidence of any knowledge of risk in this having the opposite effect. They did take the opportunity, by way of obiter dicta, to distinguish these circumstances from cases of driving or self-administering of dangerous drugs. They did say this type of these circumstances are unique, if you like, and this isn't going to extend to those type of cases. A really important case, and one which really illustrates that although this is a blanket defence, if you are involuntarily intoxicated, it doesn't distinguish between the different specific and basic intent crimes. This will only be a defence where the defendant cannot form the mens rea due to that involuntary intoxication. In the case of Kingston is a great illustration, as I say. So Kingston was a known paedophile, and a business associate set out to drug him with the aim of being able to blackmail him, essentially. So he invited him round to his flat, and once there, spiked his drink and took him to a room where a 15-year-old boy was asleep and told to abuse him. Kingston did, and there were photographs taken of the attack. Now, Kingston was initially convicted by a jury despite his involuntary intoxication, so claiming to have no understanding of what he did at the time. The Court of Appeal, when he appealed, actually quashed his conviction on the basis of him being able to prove that his drink had been spiked. The problem was, during trial, he'd admitted that he would have intended to assault the boy, had he not have been intoxicated, which essentially meant that the mens rea was there. So when the prosecution then appealed against this acquittal up to the House of Lords, his conviction was reinstated. And this just really shows you that your drink could be spiked, or you could be involuntarily intoxicated, but if the mens rea is still there, it's still present, it won't be a defence to you. So we've gone through the different types of intoxication, the voluntary intoxication, the involuntary intoxication rules. Hopefully you've identified that involuntary intoxication is going to be more available to you as a complete defence, provided that you couldn't form the mens rea at the time. We've also looked at the difference between the specific and basic intent crime categories. So this task may take you a few minutes. I want you to use this diagram and see if you can complete the boxes by going back through the rules, looking at your notes. And further than that, see if you can annotate this diagram with relevant cases. So please pause that and do that now. And this is what I hope you've come up with. You see, for voluntary intoxication, if a defendant has voluntarily intoxicated themselves, if they've committed a specific intent crime, then they will have either a partial or a complete defence, provided they cannot form the mens rea. And of course, this depends on the crime. So if they commit the crime of murder, it will be a partial defence because their liability will be reduced to manslaughter. If they complete the offence of theft, then they will have a full defence, a complete defence, because there is no alternative basic crime to charge them with. And those rules come from DPP Beard. Remember, in terms of forming the mens rea, a drunken intent is still an intent. And you could also look up a later case that also uses that principle, Sheehan and Moore. It's a really interesting case. Have a look at it and you can add it to your notes there. For the basic intent crimes committed whilst voluntary, you will have no defence to your crime if you are deemed to have been acting recklessly. And those rules come from Majewski and Richardson and Irwin. Remember, the court will consider your view of the act being reckless had you have been sober as well. So it's a bit more subjective than the blanket no defence. For involuntary intoxication, you'll have a complete defence to both specific and basic intent crimes, provided that you cannot form the mens rea. And remember, the two key cases there are Kingston and Hardie. Kingston being, of course, authority on the defendant must not be able to form the mens rea, and Hardie being authority on the widening, if you like, of involuntary intoxication to include the voluntary taking of drugs, soporific drugs that have the opposite effect. So I hope that helps. And what we're going to do, once you've annotated that, is move on to some application, looking at what we might do or how we might apply these rules to some scenarios. So please have a look at this scenario. It's typical 25-minute exam scenario, but if it was to focus on intoxication, this is the type of thing it would look like. And the question might be, advise Alvin of his liability for offences against Bella and Claire. So we have to identify what offences he's committed and, of course, any defences. And I'd need you to consider intoxication here. And the question might be specific on that point. So please pause, have a read of this. Hopefully you've identified that against Bella, Alvin has committed an assault occasioning actual bodily harm, so the assault being shouting loudly at her. She faints, but for months afterwards she's unwilling to leave her house, which makes this potentially an ABH on the basis of psychiatric injury. Against Claire, he could possibly be charged with grievous bodily harm on the basis of her suffering from weak bones. This is likely to cause greater injury to her, so using the case of Bolam, we can charge the higher level crime there. Arguably section 20, grievous bodily harm, on the basis that he kicks out wildly, so it'd be difficult to prove any specific intention to cause her serious harm here. Although he certainly caused her serious harm, take your victim as you find them, the causation rule. She suffers from weak bones. We can use Blau and both Bolam here to make sure that he can be charged with a greater injury crime here. But the question is, of course, is Alvin going to be liable? Because he's taken drugs prescribed by his doctor for illness, and then he's drunk a number of glasses of whiskey, and he's claiming he can't remember anything that happened after he shouted at Bella. So hopefully you've identified those parts of the scenario as really important. And at one point he feels a great rage. So using our diagram, the first question is, what type of intoxication is he suffering from? Now, had it have just been the effects of the drugs prescribed by his doctor, I'd be saying involuntary intoxication. But he has also drank a number of glasses of whiskey as well. So it could be that a court would consider this to be a voluntary intoxication instance here. If they consider it to be voluntary, then what type of crimes has he committed? Specific or basic intent crimes? For ABH and grievous bodily harm section 20, hopefully you identify these as basic intent crimes. Then we come down to the next part of the flow diagram. What will be the outcome? He would be deemed to be reckless. Obviously, if the court decided that he would have foreseen the commission of a crime when sober, they might allow him a defence, but blanketly applying the Majewski rules, he's unlikely to have a defence here. So that's if it's considered to be voluntary. If the courts, by nature of his prescribed drugs, considered this to be involuntary, which, as I say, is unlikely because he has decided to drink a number of glasses of whiskey. But if they said involuntary, then of course he would have a defence, provided he can't form the mens rea. The issue for me is, in relation to Bella, he feels a great rage. He goes into a cafe, he sits down at a table and feels rage. This tells me that he probably can form the mens rea towards Bella. So he probably wouldn't have a defence towards Bella anyway. But in terms of Claire, he's saying he can't remember anything that happened after he shouted at Bella. So potentially he has a defence against Claire. So he may be guilty against Bella and not guilty against Claire if involuntary intoxication is the case. So I hope that makes sense, and see if you could have a go at writing that out to make sure that you're able to apply the rules. But using the diagram, hopefully you see how I've just done that, will help you. And what we'll do is move to our final scenario for application practice. Please pause and take a minute to read this. So we've got Carol and Diana having both potentially committed offences. Carol's liability being covered in the first paragraph, and Diana in the second. So Carol takes a leather jacket from the back of a chair, mistaking it for her own very similar jacket, which she has in fact left at home. She's potentially committed theft here. But what type of intoxication does Carol have? So they began the evening by drinking half a bottle of vodka, had more drinks in the pub, and each have taken an ecstasy tablet. So hopefully you agree with me that this is voluntary intoxication. So looking at our diagram, Carol is voluntarily intoxicated. She's committed the offence of theft, which is a specific intent crime. So if you look at the next box down, she will have a defence provided there is no alternative basic crime and she can't form the mens rea. So we know there is no alternative basic crime for theft. There's no reckless theft. So it all comes down to whether we can prove dishonesty and intention to permanently deprive. It's unlikely on the facts. I think she obviously believes that it's hers, although this is a mistaken belief due to being intoxicated. As we'll see on the next slide, it's difficult to use this defence where you're mistaken due to intoxication. So actually, the outcome of this would be it depends on whether she is deemed to have formed the mens rea and how much weighting the court puts on her mistake due to intoxication. With Diana, again, voluntarily intoxicated, what she commits, she pokes the doorman's eye with her finger and knocks him unconscious with her umbrella. So she's potentially committed, I'd say, ABH level injuries here. The poke in the eye and the loss of consciousness, we know from TVDP, would be ABH level. So this is a battery occasioning actual bodily harm. So we have voluntary intoxication, we have ABH level injuries, which hopefully you've identified as a basic intent level offence. So she's going to be unlikely to have a defence based on her intoxication being reckless. So Carol may be successful, Diana unlikely to. So I hope that helps. And again, you could have a go at writing those out for practice. That would be really useful. So as I've just mentioned, making a mistake due to intoxication is seen as the courts are less likely to allow you this, particularly if this is due to voluntary intoxication. And I refer to a case of Lippmann, 1970, where this was a man who took LSD, so a hallucinogenic drug, on a night out. He slept in bed with his girlfriend that night. Whilst he was hallucinating, he believed he was being attacked by large serpents. This is the evidence of him, so large snakes, and he was defending himself from that attack. He woke up in the morning to find his girlfriend dead, and he'd actually strangled her. So clearly killed her during this hallucination. It was clear on the rules, if you go back to your flow chart, voluntary intoxication, charged with murder, which is a specific intent crime, but the fact is he couldn't form the mens rea on his evidence of the intention to kill her or cause serious harm to her under that influence. So he was convicted of the alternative basic crime of manslaughter. So the court still convicted him of something despite his mistake possibly being a genuine one. And of course, it kind of lends itself more to the self-defence argument. He believes he's defending himself against an attack. And that was similar to the case of O'Grady. If you remember, we looked at this case, 1987, in our self-defence lesson. O'Grady, obviously under the influence of believed that he was being attacked by somebody in his house, and he killed them. He claimed that he believed he was using self-defence, but of course he was intoxicated at the time, and he was not afforded the defence. And this was subsequently inserted into the key legislation for self-defence. So if you remember the Criminal Justice and Immigration Act 2008, a defendant can rely on self-defence, even if they were mistaken, as long as that belief is genuine. And that's under section 76, subsection 4, section B, if you the blue box. So you can, in normal circumstances, be mistaken in your belief for use of self-defence. That comes from the previous case of Beckford, so the key case for self-defence there. But note here, unless that mistake was attributed to voluntary intoxication. Section 76, subsection 5, prevents a defendant from mistakenly overestimating force where they are intoxicated. Okay, so let's move on to the evaluation of this area then. So I've separated evaluation out into three kind of categories or three paragraphs. The first being the fact that intoxication is an issue of public policy. So it's one that is on the government agenda. It has risen and fallen over the last 50 years. Probably through lockdown, it's less of an issue than it ever has been, to be honest, until the pubs open soon. But of course, the role of the courts is the need to balance the safety of the public against, of course, upholding legal principle. And that's where some of these legal principles we've learned in this session can really cause some difficulty. We are blanketly labelling defendants as reckless so that we can enable a conviction. But equally, we are also allowing defences to murder, where we say that even though they are to blame for their intoxicated state, they can't form the mens rea. And you see, the reason why it's such an issue and it's such an important decision and role of the courts in upholding this area and making sure that they don't set too strict or too lenient precedents is because intoxication is one of the main causes of crime. In 2018, there were 561,000 intoxication-related incidents. Intoxication is to blame for 39% of all violent incidents, and that's in England and Wales. The figure's slightly higher in Scotland, and it's slightly lower in Northern Ireland. And the burden on the NHS, and of course then us taxpayers, makes up between 1.3% and 2.7% of taxpayers' money. This is approximately between, it's quite a wide approximation, but 21 and 52 billion pounds. This is how much money we spend on the effects of drink or drugs by defendants and people. And of course, many of these instances, we separate intoxication into those one-off incidents, those binge drinking incidents, or those that are dependent, which of course require treatment, and we then leads to more financial consideration there. So although there are some inconsistencies or some potentially unfair decisions, we have to be mindful of the overriding objective of keeping the public safe, which of course has to be the role of the upper courts, the Court of Appeal and the Supreme Court, but also making sure that we are backing those decisions up legally as well. The need to form the mens rea, which kind of leads to the second point, really, the problem with the defence. So are the rules fair? Should this be a defence at all? Some critics argue we shouldn't be able to have a defence at all in court if intoxicated. So really, to develop this paragraph, you need to be examining the rules of voluntary and involuntary intoxication and identifying whether they are fair, identifying the inconsistencies. And of course, the rules depend on the categorising of crimes. Does this system work? Is it consistent? We know already that it isn't consistent. There aren't corresponding basic alternative crimes for every specific crime. For murder, manslaughter, grievous bodily harm, it works. But for the property offences and for attempts, it doesn't. There is no alternative basic crime, which means that defendants will have a defence if they convince the magistrates or jury that they couldn't form the mens rea at the time. So this is a problem. So an example of a well-developed point, one of which would get you 3 or 4 marks, let's say, in an essay. So it's the role of the court to strike a balance between protecting the public and adhering to legal principle, e.g. applying rules relating to the tests and actus reus and mens rea strictly. So we see that with Beard, with Majewski, with Kingston. This can lead to problems as it is necessary to criminalise drunken behaviour. Yet this can affect the ability of a defendant to raise a defence based on the failure to meet the requirements of an offence, i.e. the mens rea. For example, the case of Majewski made a blanket policy that if a defendant committed an offence which requires basic intent or recklessness in an intoxicated state, then the defence is unavailable due to his conduct being reckless. You could develop this point further by saying this is potentially unfair because it means that anybody who chooses to become intoxicated is therefore deemed by law as reckless. It certainly needs some reform. So remember, in an essay, you're aiming for 4 well-developed points. You can have a look at the other categories and try and come up with some more developed points there. What will get you into level 4 for an essay will be citation of reform. We know that this area is problematic, and we have a number of bodies that have reviewed this area. So the Butler Committee, which was what we call a royal commission set up specifically in 1975 to look at offences, suggested that the current law be replaced with a new offence of dangerous intoxication. Now, that would be related to self-induced intoxication, where the prosecution would have to prove that the defendant became intoxicated voluntarily. For the first offence, the sentence would be 1 year imprisonment, and then there would be a maximum of 3 years imprisonment for any subsequent offences. That has not been implemented, obviously, but there are some countries that have considered it. The Law Commission has reviewed this area across a number of years. 1993, first and foremost, where they released a report in 1995, and then later, 2009, the paper called Intoxication and Criminal Liability. And they actually proposed a draft bill called Criminal Law, in brackets, Intoxication, close brackets, Bill. So they reviewed the rules of intoxication, both voluntary and involuntary, and they suggested a number of things, really. You could read this report online, but what they suggested was that rules like Majewski are kept but codified. They suggest, actually, in the 2009 paper, to tighten the rules of involuntary intoxication, particularly in relation to sex offences. So that would be reflecting the decision in Kingston, if you like. Also, what they said was give all crimes a corresponding basic crime, or get rid of those rules altogether. And what they've always suggested is that the existing law be codified. So across these 3 years you've got here, or 3 or 4 years, they've suggested to codify the existing area, put it into a bill, one code for everybody, to be able to find the law in one place. So I hope that helped. And what I have on this slide, which you'll need to pause and just have a read of it, it's a really in-depth task. It is an exemplar answer provided by OCR to the essay question: the defence of intoxication is not fit for purpose and needs to be reformed urgently. Discuss the extent to which this statement is accurate. So again, a very common essay question. So I want you to read this exemplar. It is available on the OCR website as well. I want you to identify how has it been structured. So what does each paragraph cover? And do you agree with this receiving level 4 marks, which, as we know, is an AA star grade? So you've got paragraphs on voluntary intoxication, paragraphs on involuntary, and then, of course, a paragraph on reform at the end and the linked conclusion. So please do take time to read that, and that will show you how an essay could look. So well done, you have finished Intoxication. And some advice from me for consolidation would be write out an AO1 paragraph for each of your defences, obviously including Intoxication. You can use your diagram to do that. So try and write your diagram out into short paragraphs. Make sure you've got everything annotated with key legislation and case law. You could put your key law onto flashcards to help you to learn. Practice the application scenarios in this booklet. If you need more, you can ask me. And then use mind maps to write out your evaluation points. And I hope you found that useful. It is a bit more of a longer tutorial because the defence itself can be a bit more complex, but I hope you found it useful. Thank you.